Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. In the event Brian C. Kohberger files a petition for post-conviction relief, what would be 3 things that could be expected to occur thereafter? The answer to that question is found at Idaho Code Section 194906, entitled Pleadings and Judgment on Pleadings. The first thing that could be expected to happen would be within 30 days after the docketing of the application, or within any further time the court may fix, the state shall respond by answer, or by any motion which may be supported by affidavits. So this is found under Section 194906. And the big point that we see here is that the state would have 30 days after the petition for post-conviction relief is docketed. That means after it appears on the docket in Ada County. Or there might be a shorter or longer time than that 30-day window that may be fixed by court order. The second item is found under 194906B. And this reads, when a court is satisfied on the basis of the application, the answer or motion, and the record that the applicant is not entitled to post-conviction relief and no purpose would be served by any further proceedings, it may indicate to the parties its intention to dismiss the application and its reasons for doing so. The applicant shall be given an opportunity to reply within 20 days to the proposed dismissal. So the second thing that we could expect for relief under the Idaho statute, and no amending of anything, no additional information would change that matter. The court would then give an intention of dismissal and the reasons for doing so. Then the applicant, who would be the moving party, would be given a chance to reply within 20 days. This would be presumably to state why the petition should not be dismissed. The third thing that could be expected to happen under, this is Section 194906C, the court may grant a motion by either party for summary disposition of the application when it appears from the pleadings, the depositions, the answers to interrogatories, and admissions and agreements of fact, together with any affidavits submitted, that there is no genuine issue of material fact, and the moving party is entitled to judgment as a matter of law. So we see here, this operates as a summary judgment rule. For example, when a lawsuit is filed in state or federal court. So we see here that there is an opportunity for discovery to happen, judgment as a matter of law. And this goes for either the petitioner or for the respondent. And again, all of this information can be found under the post-conviction relief statute section, specifically 194906. Finally, ladies and gentlemen, we have a poll that is currently ongoing on our YouTube channel's community page. I've provided a link in the description to this podcast episode. It is asking for your opinion. If you feel, in light of the 1-year statute of limitations that is approaching, Mr. Kohberger will either miss that statute of limitations and not move for post-conviction relief, or if you feel, conversely, that he will make the statute of limitations and will file a petition for post-conviction relief. Please be heard on that matter. Until next time, this is Kathy. Thank you for joining us here today.